Disney's having some good times right now. Over 100 million subscribers to Disney Plus. They just celebrated a 50-year anniversary at Walt Disney World. They're getting a lot of things going on well for them. People are buying cookies and getting on long super lines for the Lightning Pass and all this kind of stuff. So yeah, they're doing okay. They're doing okay. But with all that kind of money, it doesn't mean they don't have their own kind of issues. Hollywood Reporter talks about how Disney has an Avengers-sized legal problem, maybe bigger than it realizes. As I record this episode, I already know that Scarlett Johansson received most likely a $40 million payoff, or a settlement for $40 million for the Black Widow issue, where she was not getting proper royalties for the streaming of the movie on Disney Plus per her contract. So, Marvel movies, with the money they're making with it, they're going to have to pay some people back. So here's what we have. The issue of copyright termination over characters like Spider-Man and Thor. And that Disney might have to continue to do a little more settling on some things. Now, Hollywood Reporter first talks about Disney's Marvel unit was facing off in court against the estate of comic book legend Jack Kirby, whether its heirs could terminate a copyright grant and thus reclaim rights to characters, including Spider-Man, the X-Men, Incredible Hulk, and the Mighty Thor. Disney was winning in this case, but then a federal court ruled in 2011 that Kirby's contributions as an illustrator from 1958 and 1963 were works made for hire, and so his heirs had no standing to terminate the grant of copyright. Then 2014, the Kirby estate went to the Supreme Court, and the justices of the Supreme Court actually intervened and then snapped their fingers like Thanos to change the fate of the Marvel Cinematic Universe. Disney blinked. The companies couldn't take the chances of losing, no matter how small. It settled with Kirby's estate, with insiders placing the value at tens of millions of dollars. So now we're getting another attempt at copyright termination from the heirs of comic book authors, including Spider-Man co-creator Steve Ditko, and one must wonder whether history will repeat itself. In seeking declaratory relief through preemptive lawsuits filed on Friday, this past Friday, as I recorded this show in October, or first week of October, they mentioned that Disney hopes the judges will come to the same conclusion that Ditko's contributions on characters including Iron Man, Loki, and Doctor Strange were works made for hire. But even if Disney repeats its success from a decade ago, they would still need another trip to the Supreme Court. Same issue as the petition that compelled a settlement 7 years ago. Now, will the new leadership at Disney want to settle? Like, are they more risk tolerant? And that's the only reason why this latest copyright termination wouldn't settle. So, they talk about Disney's risk in more detail. The nuances of copyright are less understood in the MCU universe, or the metaverse. Now, they go into the whole reason as to why things were going on. In the mid-1970s, Congress decided to allow authors or their heirs to reclaim rights once granted to publishers after waiting a statutory set period of time. So most of the writers and illustrators that worked for Marvel Comics back in the 1960s did so on a freelance basis in a highly collaborative environment. So there's really can't be said who's the actual quote-unquote author of a character like Spider-Man, Ditko, Stan Lee, Marvel, all the above. So these days when a work is created as a made-for-hire, it means the employer is deemed the author. There's a written document that spells it out. But in the 1960s, when everyone was operating under a copyright law for 1909, such paperwork often was never completed. So courts had an elaborate test they created to figure out when older commissioned artworks are made for hire. So Disney believes the freelance contributions were done at Marvel's instance and expense, and were not authored, and they were authored by the company, not by individual writers and illustrators. And Disney has a fallback. Even if judges decide Spider-Man, Iron Man, Thor aren't works made for hire, and rights grants can be terminated, these characters would be a joint work. So Marvel would still be a co-owner. Under U.S. copyright law, co-authors are allowed to freely use and license work. They must share revenue with each other, but this means that whatever happens in court, the comic book author heirs can't block the making of new movies in the MCU. So that's what they want to be able to do. Continue to make movies, continue to profit and milk the MCU dry. And putting movies out that are going to cost hundreds of millions of dollars to make, to generate billions of dollars to prop up streaming services like Disney Plus. So sharing impacts could lead to the economic structure of production distribution being more to lead court battles like there was with Scarlett Johansson. Copyright laws could also be an issue overseas. So termination of provisions of the U.S. copyright law only impact the domestic market, but there are also foreign laws, like in Canada, for instance. Canada mandates automatic reversion of the copyright to the estate 25 years after the author's death. And so in Canada, joint owners may not license jointly owned work to others without the consent of the co-owners. So if a future season of Loki was prevented from being shown in Canada, the suggestion of something like this occurring would be crazy and dangerous to even broach it, and yet Disney was willing to settle. That's what they're talking about. So there's a chance that Disney could do a similar weighing of the risks. Right now, the entertainment giant will hope for a momentum in court and leverage before getting serious about a negotiation. But at some point, the stewards of the MCU will have to contemplate the truly unimaginable. So Marvel movies being made and having to go and make sure that the people that were behind it are being done. Like, that's a pretty big thing to deal with. And a story from Screen Rant also followed along. They have every character Marvel is suing creators of the rights of. They went through a whole list. So when you're looking at the list right now, Iron Man is one. Then there's Thor. Then there's Ant-Man, Spider-Man, Doctor Strange, Black Widow, Hawkeye, Carol Danvers, Falcon, Blade, among others. And in the story they make the mention of, from the beginning, ever since the success of Iron Man in 2008, Marvel Studios has built a widely successful franchise of interconnected superhero films and TV series, aided by the acquirement by Walt Disney Studios in 2009. According to the Copyright Revision Act of 1976, copyright ownership should revert to the original creators 60 years after their product's creation. So with some of these, you have writer and artist Larry Lieber filing a lawsuit to retain rights for several characters. He's also been joined by the estate of Steve Ditko, the estate of Don Heck, the heirs of Don Rico, and the heirs of Gene Colan. So, yeah, the writers, the illustrators that worked on this all before, and now all these movies are being made after the fact, yeah, they want their family members to benefit on their works, on their creations, as they say. But they either have it where it's a joint ownership, which means that Disney can still keep cranking out Marvel movies like they do, or that a bigger piece of the pie goes to the owners, and then Marvel can't, and the Marvel Studios cannot make any more movies off of them. So people should keep an eye on that. It's actually an interesting story. Hopefully that doesn't mean we're going to get any shut down of the movies altogether. Anyway, that's it for this episode. I'll talk to you next time.